So the first slide you see on the screen is what we call WIPO Pulse. This, first of all, is the first time any organization, any entity has taken a survey of the average person on the street. So WIPO, the first time what we did was we took 50 countries, and in those 50 countries we interviewed 25,000 people. These were not intellectual property experts. These were your average person on the street. And the questions were meant to determine what the average person on the street thought about intellectual property. Certain findings were quite surprising, unexpected. For example, it turns out the most well-known intellectual property is copyright. For Africa, that may not be a surprise considering we have music and dance in our bones. So clearly, copyright is the most important for the African continent. But another surprising revelation of this WIPO Pulse was the fact that it turns out the youth who, as you know, constitute the majority of the population in Africa, are not as well tuned into intellectual property as grown-ups. That was a surprising revelation. The third and revealing statistic that came out of this WIPO Pulse is the fact that it's in developing countries that they seemed to have a hunger for intellectual property. They have a greater knowledge of intellectual property in developing countries than in developed countries. So Africa, Latin America, and the Caribbean, Asia Pacific, those were the regions that were most interested in IP and that spent a lot more looking into IP issues. The way my Director General explained it is that it's in the developing countries that we are hungry for information. He said developing countries have a hunger for intellectual property information. And that is what would explain why it's developing countries that seem to be more interested in intellectual property. With all that in mind, this year we have done a second survey. This time the survey interviewed 70 countries. It was actually 74 countries, but 70 sounds more rounded off. So we either say 70 or we say 75 countries, but it was 74. And they had similar statistics in terms of which countries, which regions have the most interest in intellectual property, what type of intellectual property is the most listened to. We will be doing, I am told, a third iteration of this survey in another 2 years, just to see where WIPO Pulse takes us to. So that's it for intellectual property statistics. Now back to the first item of coherence and interrelationships, WIPO, WTO, and the African Free Trade Continental Agreement. The reason you only see WIPO and WTO is simple. So before WTO in 1995, WIPO was the only organization dealing with intellectual property. The members of WTO, when WTO was established in 1995, and the member states of WIPO, which was established as far back as 1970, although we go back to what we call Bureau International Réuni pour la Propriété Intellectuelle, and they are more than 100 years old. Since it's essentially the same member states, they said, WIPO and WTO, we want you to avoid duplication of effort. We don't want you to fight over territory, and we want to make sure you are not doing the same thing. So we want you to come up with an agreement delineating collaboration between WIPO and WTO. And that's why there is a 1995 agreement. This agreement entered into force 1996 between WIPO and WTO. And it lays out 3 specific areas for the two to collaborate. The three areas are first what they call deposit of laws and regulations. So what now happens is when any WTO member informs the WTO Secretariat of their specific laws and regulations, the WTO Secretariat has an obligation to in turn notify not just WTO members, all 166 of them, but also all WIPO members, meaning 194 minus 166 who do not happen to be WTO members. So WTO Secretariat notifies them. Alternatively, when a WIPO member state notifies the WIPO Secretariat of any laws or regulations it has adopted, now the WIPO Secretariat is also obliged to notify all the other WTO members of the WIPO member states' legislation. That's the first area of cooperation. Second area is what we call implementation of Article 6 ter of the Paris Convention. The Paris Convention, as you may know, is the Paris Convention for the protection of industrial property. So this deals with industrial property. And Article 6 ter is the provision through which any country can notify its national emblem, its logo, its artifacts to the WIPO Secretariat. WIPO administers the Paris Convention. So Article 6 ter of Paris is administered by WIPO. And we in turn now have to notify not just the WIPO member states, but also the WTO members. To give you a practical example of what is done here, South Africa, I'm not sure if there's a South African here, but South Africa, just to give an example, has notified what they call a national emblem to WIPO, and WIPO in turn has notified that national emblem to all the Paris Convention countries, telling them they are obliged to refrain from giving a trademark to anyone whose purported trademark is in conflict with the South African national emblem. And in this case, the South African national emblem is the face and image of Nelson Mandela. It's been adopted by South Africa as a national emblem. And so that national emblem is protected under Article 6 ter of the Paris Convention. And that is one of the main areas where WTO and WIPO collaborate. The third and final area listed on this slide is legal technical assistance to WIPO and to WTO. Clearly, the TRIPS agreement, we all know, is administered by WTO. And yet you will be surprised to know most of the technical assistance under the TRIPS agreement is actually provided by WIPO, not by WTO. Why? Because WTO has an intellectual property and investment division. That division has a total of 8 lawyers. 8. WIPO, on the other hand, has almost 500 lawyers, IP lawyers, dealing with trademarks, patents, copyright, designs, geographical indications, etc. So WTO relies on WIPO to provide most of the technical assistance that needs to be provided under the TRIPS agreement. And that's a specific area of collaboration between WIPO and WTO. That takes me next to IP and development, an overview. I've already said a little bit on development, but just so you know, I have also put slides on this PowerPoint for your information. So when we talk about IP and development, the question raised is, what's the issue about IP and development? We are talking mostly about sustainable development. And that's why in this slide, for example, you see the connection between intellectual property and the SDGs, which, as we were reminded today, are set for attainment in 2030. But we've also been reminded there is no way the international community will be able to get to the 2030 goals. So linking IP to sustainable development. We have examples, frontier technologies and social innovations that have helped the international community leapfrog in terms of development. And so clearly it's an important thing. I mentioned the WIPO development agenda, and I am happy to say a bit more about it. The issue again, like I said, is first of all, keep the historical context in mind. International organizations all have different mandates. Some of these mandates, you take UNCTAD, for example, it's now called UN Conference on Trade and Development. You take UNIDO, United Nations Industrial Development Organization. The World Health Organization is doing a lot in intellectual property. IBRD, they already have International Bank for Reconstruction and Development. So they have the word development in their name, not to mention Food and Agricultural Organization of the UN or the European Patent Organization, etc. These are all different intergovernmental organizations with development in their respective mandates. I think the other reason why we have development coming up in intellectual property discussions a lot more is the simple proliferation of intergovernmental organizations and international organizations dealing with development. The example I've given here is the South Center. The South Center, as you may know, is an intergovernmental organization. It's mostly developing countries. They are based in Geneva, and they articulate reasons of importance to the developing countries. So the more we have such organizations, the more there is discussion of development issues, also in the context of intellectual property. Now, some may think this is not an important point. I've written increase in the heads of intergovernmental organizations, or increase in the heads of international organizations from developing countries. So let me just take 3 quick examples, all based in Geneva. The World Trade Organization, it's headed now by a Nigerian. The World Health Organization, it's headed now by an Ethiopian. The World Intellectual Property Organization, it's headed now by a Singaporean. Several other examples I could give. The International Labour Organization is headed by a Togolese. So the point is, a lot of international organizations now have developing country citizens heading those organizations. The fact that the head of the organization is from a developing country doesn't necessarily mean all that head is going to talk about is development. But still, it is symbolic. And for example, when Kofi Annan was the Secretary General of the UN, there were a lot who criticized him because they said he wasn't bringing enough jobs for the boys and the girls. Meaning Kofi Annan didn't excel himself in bringing staff members from the African continent. So the fact that you have a Ghanaian heading an organization doesn't necessarily guarantee you will have more Ghanaians or you will have more Africans in that organization. But I don't think we can get away from the fact that the more developing country nationals you have heading organizations, the more those nationals are going to try and infuse their organizations with people, citizens from their countries. So this also increases the extent of discussions about development. Globalization, we all know there's greater interconnectedness, no need to make a case for that. But when all this is said and done, I think it's important we remember whether development has a distinctive role in intellectual property discussions is also a function of what type of intellectual property we are talking about and what country's level of development is. So, for example, patents will have a different impact than copyright would on a country. Just like patents in a developed country would have a different impact on that developed country than they would on a developing country. So just keep in mind when we talk about development being infused in intellectual property discussions, we also need to keep in mind what type of developmental level the country has and what specific aspect of intellectual property we are talking about. Now you'll see me trying to run through the slides a lot more just so I can make sure I've gone through the majority of it. These are just two quick examples. There's one from India, but this is more focused on the African continent. So I've talked about how drones have been used in Rwanda as a way to target communities using drugs. I have also given the example of mobile phone use, and we all know how M-Pesa has become very widely acknowledged, not just in Kenya where they invented it, but also in several other developing countries. This is WIPO's development story, and I think I've already said enough about it. So, now we can go to concluding when it comes to development, and you may have something for or against Joseph Stiglitz, but I think this one particular quote from him is something we can count on. Stiglitz tells us development is about transforming the lives of people. It's not just economies that development is transforming, it's transforming the lives of people. Very important conclusion. That conclusion, I believe, should be intellectual property. It doesn't matter how well you protect it, it doesn't matter how well you know it, and this is intellectual property being espoused by WIPO or by WTO or by AfCFTA. The important thing about it is we are talking about it as a means to an end. We are talking about intellectual property as a means to an end. So we are going to protect it because we are using it as a means to an end. Innovation itself is the catalyst in that sense. And finally, it's sustainable development that is the ultimate goal. So let's talk about intellectual property in the sense of this is what's assisting us in attaining our developmental goals. I was going to say if there's a question or a comment, I'm happy to stop now, but I think it's better I try and rush through a few more of these slides, and then at the end we'll have a Q&A section. So very quickly, as you can see, the trade-related aspects of intellectual property rights is one of the main topics that had been assigned for this afternoon. And I have what I think are the relevant aspects of TRIPS included in this slide. The important thing to remember is how intellectual property became linked to trade. One thing you should remember, and this comes up when we start talking about traditional knowledge, traditional cultural expressions, and access to genetic resources. When it comes to intellectual property, we all know, going back 30 years before WTO, the developed countries have a preponderance in the world's intellectual property. And here I mean trademarks, I mean patents, I mean copyright, I mean designs. Developed countries owned the majority of the world's intellectual property. So during the Uruguay round negotiations from 1986 to 1993, 1994, the developed countries made sure they insisted that intellectual property was linked to trade. They saw intellectual property as being trade-related, and for that reason, they wanted to ensure they brought into the WTO not just discussions on goods, but also discussions on services and discussions on intellectual property. That's how we ended up with the TRIPS agreement. Developed countries decided, we have a majority here. We have a perceived need to make sure our intellectual property is protected. So we are going to insist that we bring it to WTO and protect it through the dispute settlement understanding. That was how we got the TRIPS agreement, and this is why we needed an agreement on TRIPS, so we could avoid you going around trade-offs, etc. Now, this is a reference to the concept of balance, which I talked about earlier, and I don't need to dwell on it. What TRIPS does is it incorporates agreements by reference. So it says we are hereby incorporating 4 main treaties of WIPO: the Paris Agreement on Industrial Property, the Berne Agreement on the Protection of Literary and Artistic Works, the Integrated Circuits Agreement, and then finally the Rome Convention. TRIPS incorporates all these 4 by reference. In respect of every type of intellectual property, TRIPS gives what we call basic principles and obligations. It gives minimum standards of protection that cover the subject matter to be protected, the rights that are conferred for each of the 7 types of IP, and the term of protection. So, for example, when it's patents, term of protection is 20 years. When it's trademarks, term of protection is 7 years, and that's renewable so long as you can show the distinctiveness of the particular trademark. When it's copyright, it's the life of the author plus 50 years. Although several jurisdictions have made it the life of the author plus 70 years instead of plus 50. So each different type of IP has different terms of protection. We also have the transitional provisions. The transitional provisions are what recognize the fact that certain countries are at certain levels of development that make it such that they would need specific types of assistance. So, for example, when TRIPS was adopted, they decided all developed countries would be given just 1 year within which they have to start complying with their obligations. Developing countries, they decided, would be given 5 years within which they would have to start complying with their obligations. And then least developed countries would be given 10 years. And that 10 years was subsequently increased. And now in respect of pharmaceuticals, for example, it's going to 2034. So there are different transitional provisions taken into account the fact that different countries have different levels of economic development, and they will need different types of assistance to be able to start complying with their obligations. In a sense, when you think about it, these transitional provisions may be a bit tricky. Tricky in the sense that under the UN, under the World Bank's classification systems, a country like Singapore is called a developing country. Or let me take even China, the world's second biggest economy. They are called a developing country. So how do you equate China with my small country, Ghana, and say China and Ghana will be held to the same standards of protection because they are both developing countries? But that's what the system provides. And UNCTAD is the country, the organization responsible for determining which countries will be called least developed countries. So every 3 years, UNCTAD takes into account various statistics, including gross domestic product, ease of doing business, investment prospects, things like that, to determine which countries remain as least developed countries and which countries graduate to developing country status. So I'm saying, although we have transitional provisions in TRIPS, that distinction is somewhat artificial. The preamble, I have put a whole slide on the preamble just to make one simple point. For those of you who take public international law classes, when you do treaty law, your professor will keep harping into your ears the preamble to any agreement is insignificant, or the preamble to an agreement is not an integral part of the agreement, so you can forget about it. When it comes to TRIPS, I simply want to remind us all the preamble is probably the most important aspect of the TRIPS agreement, because it's in the preamble that they talk about everything, including the need to avoid distortions to trade, the need to cater for the special needs of the least developed countries, the need for, and WIPO happens to be the only organization mentioned in the preamble to the TRIPS agreement. Basically, the preamble gives us the background to the TRIPS agreement and why we are going into the TRIPS agreement. That's the structure for each of the 7 types of IP. They try and provide a definition where possible. They talk about conditions for protection. They talk about exclusive rights, and then the exceptions and limitations to those rights. I have highlighted 2 particular articles because of their relationship to the concept of development, and that is Articles 7 and Article 8 of the TRIPS agreement. First of all, these 2 articles were both included at the insistence of the developing countries during the Uruguay round negotiations. So Articles 7 and 8, let's keep in mind, they are there in TRIPS because developing countries wanted them. Article 7, it simply says, protection and enforcement of intellectual property rights contribute to. So it doesn't matter what our philosophical leanings are. I may be standing here and saying we are wasting our time protecting intellectual property because protecting intellectual property does not result in the effective transfer of technology. Well, the TRIPS agreement, an international agreement binding on all 166 WTO members, specifically says when you protect intellectual property, you promote technological innovation, and TRIPS says you actually transfer and disseminate technology. So I think that the debate has been ended by the TRIPS agreement telling us, yes, that's what protecting IP means. And if you are not someone who is interested in IP, unfortunately, you can't turn this around and say, no, protecting intellectual property does not result in technology transfer. We are told in the TRIPS agreement itself, that's exactly what the protection of intellectual property does. It does this to the mutual advantage of producers as well as of users. And here again, we have the balancing act being repeated in order to balance rights and obligations. Similarly, Article 8, and this is the article that was used by the Australian government in the tobacco plain packaging case that I referred to, where Australia decides for the public health of our citizens, we are going to put certain restrictions on intellectual property rights, in this case, trademarks. This also happens when it comes to compulsory licensing, meaning patents, for example. You are allowed through Article 8 of TRIPS to impose certain restrictions on entities if you are trying to attain the global health, the public health of your citizens. And then we go into substantive issues. This is copyright and the protections and the automatic protections and all that. What is not protected? I just want to remind us all, you'll normally hear someone say, oh, they stole my ideas, so they've stolen my copyright. When it comes to copyright, it's not the idea that we say someone has stolen, but it's the expression of the idea. So in the case of copyright, it would be, for example, if you wrote a performance, if you performed a play, if you wrote a book, it's the way you've expressed those ideas that is being protected, not the ideas themselves. That's one essential thing about copyright. And what we are protecting in copyright is not ideas, not procedures, not mathematical concepts. We are simply protecting originality, the expression of the ideas in the originality. In the same sense in which when it comes to trademarks, what we are protecting is distinctiveness. The distinctiveness is what we protect when it comes to trademarks. When it comes to patents, we are protecting the level of innovation. We want to be sure if it's inventive, if it goes beyond the prior art. So the different types of intellectual property have different attributes as to what can be protected and what cannot be protected. Take trademarks, for example, and this would be uniform whether it's a WIPO treaty or a WTO treaty or an AfCFTA treaty. A trademark it could be a personal name, it could be a letter, it could be a numeral, it could be a figurative element, and it could be combinations of colors. The important thing about trademarks is that it's a sign or combination of signs, the trademark. Those signs or combination of signs are capable of distinguishing the goods or services of one undertaking from those of another undertaking. And so long as we have this, then we say we have distinctiveness, and so we can protect it as a trademark. I'm running through the different types of IP. Geographical indications, I think, are the least talked about, but also probably the most important when it comes to the African continent. Why do I say that? I think lots of African countries have geographical indications that they could actually use to benefit their economies. We take Tanzania, for example. I've actually checked a few days back, and it's been confirmed, at least in writing, that Tanzania, unfortunately, currently does not protect any geographical indication. And when you think of Tanzania, even this water here called Kilimanjaro, I had always assumed it was a geographical indication. It turns out it is not. The point I'm making is I think African countries, and Tanzania, they can talk about, Tanzanite is also not protected, I understand. But maybe there's some type of coffee, Zanzibar coffee or something, that potentially could be protected under the TRIPS agreement. And this is one area in which AfCFTA, ARIPO, OAPI, and WIPO should be able to help countries to commercialize their intellectual properties. Other countries, let me use my own country, Ghana. 2 years ago, the Ghanaian government decided we needed to enact legislation to protect certain geographical indications. And so they've currently protected the kente cloth. The kente cloth used to be protected under copyright law, but now it's protected as a geographical indication. They've also protected what we call the Bolga baskets. These are types of baskets done only in the northern region of Ghana. And then finally, there is a shea butter and pineapple loaf. Pineapple loaf is the pineapple that's very sweet, and Ghana claims you can only find it in certain parts of Ghana. You can't get it, not even in Uganda. I say this because my wife is always arguing with me that Uganda's pineapples are nicer than Ghana's pineapples. And I ask her, why doesn't Uganda go and protect its pineapples under geographical indications then? Ghana, it turns out, has done so. And we expect Ghana will end up profiting by exporting more Ghanaian pineapples to the West than it currently did, before it enacted geographical indications protection. The thing about geographical indications is you can only get protection when you have protection in the home country. Unlike copyright law, where you can get copyright protection in any country, irrespective of protection you may or may not have in your country of origin. So in that sense, geographical indications are important, and I'm sure most of our countries should be in a position to be able to protect their specific geographical indications, like South Africa has done when it comes to Pinotage wine or Karoo lamb or rooibos tea as examples. So that's geographical indications, industrial designs, and all these you see they have a term of protection. Now let's come to patents. When we talk about patentability, we say you only get a patent when it is new. New being it goes beyond the prior art. It involves an inventive step, meaning it can be industrially applicable. And finally, it's capable of industrial application. Patents are important because when it comes to TRIPS, the TRIPS members had said they would continuously examine the relationship between the TRIPS agreement and the Convention on Biological Diversity. This morning we heard Professor Francis Cranch say a little bit about the Convention on Biological Diversity. It turns out the WTO members have never done what they were mandated to do under paragraph 12 of the 2001 Doha Declaration. They were also supposed to examine traditional knowledge and finally other new developments as raised under Article 71 of TRIPS. None of this has happened. But the important thing is the WTO members have actually made an amendment to the TRIPS agreement. And this amendment is very important because it affects our African countries a lot. In fact, this amendment was passed specifically at the insistence of African countries, especially the least developed countries. So this is what we call compulsory licensing. The TRIPS agreement doesn't use the phrase compulsory licensing, but Article 31 of the TRIPS agreement, when it talks about other use, is talking about compulsory licensing. And compulsory licensing, as you know, all it is a government can decide to compel another company to produce generic versions of an otherwise patented drug. The idea normally would be to be able to get cheaper versions of the patented drug. Before the TRIPS amendment, these were the conditions under which any government could undertake compulsory licensing. It had to be without discrimination. It had to be considered on its merits, any application. The scope and duration of the compulsory licensing had to be predetermined. And then the text in red, that's what I want to highlight your attention to. If you produced generic versions of a patented drug, those generic versions had to be predominantly for the supply of the domestic market. So if Tanzania, or maybe it's a bad example, but let me use Tanzania. Tanzania has a problem with malaria. So people who are getting malaria in Tanzania are being encouraged to take Malarone every day. It turns out Tanzania decides, but the Malarone is too expensive for the average Tanzanian, and we need cheaper versions of the Malarone. The Malarone patent belongs to, let's say it's Novartis in Switzerland. So Tanzania can decide it is going to find a company here in Tanzania to produce generic versions of Malarone, meaning it will sidestep the patent of Novartis so that the generic versions produced here in Tanzania are cheaper and more affordable to Tanzanian citizens. But it turns out Tanzania doesn't have any company in this country that can produce generic versions of the Malarone. So compulsory licensing becomes useless to Tanzania. Compulsory licensing is only useful to Tanzania when Tanzania can say to South Africa next door, South Africa, can we import the generic versions of the Malarone that you have produced in your country so that our citizens also have cheaper drugs to take and not get malaria? And so WTO members decided they would remove the text in red, meaning a country like South Africa can now undertake compulsory licensing, and it can ship the generic versions produced through compulsory licensing to Tanzania, which does not have the necessary manufacturing capacity. And that way, South Africa benefits, but Tanzania too benefits. This is a very important amendment to the TRIPS agreement. Clearly affects a lot of countries in Africa that do not have the necessary manufacturing capacity, and that can now benefit from compulsory licensing. So this is an example of the intellectual property system having been used or having been put to good use to show how we can use the IP system to generate outcomes that are more useful and more beneficial to countries that previously did not benefit from it. That is what is meant by compulsory licensing. When this amendment was adopted, incidentally, WTO members gave themselves an initial 2 years, and they have had to extend the 2 years until 2017. From 2003 until 2017, when the amendment finally entered into force. And as at today, it is binding on 148 of WTO's 166 members. The last slide on TRIPS is on the transitional arrangements, which I already mentioned. So now I see it's 3 o'clock. And Matthias, can you please remind me if the idea was that I stop here, or I can still go another 10 minutes? Okay, proceed. So TKTCs and access to genetic resources. This is important because I have all along talked about WTO and how the developed countries had a preponderant advantage when it came to intellectual property, trademarks, designs, patents, copyright, etc. Now we come to what we call traditional knowledge, traditional cultural expressions, and access to genetic resources. What is traditional knowledge? Traditional knowledge is knowledge which results in creation, knowledge which results from intellectual activity. And this intellectual activity is done in a traditional context. So it's traditional knowledge, and it's, in a sense, intellectual property. Proponents of traditional knowledge, traditional cultural expressions, and access to genetic resources say it includes know-how, it includes skills, it includes innovations, and it includes learning. So this is the same as intellectual property. When it comes to traditional cultural expressions are forms in which traditional knowledge and culture are expressed. So they can be expressed in the form of performances, in the form of songs, narratives, designs, etc. One important distinction between intellectual property, as we've always been told, and this type of intellectual property is that it could be tangible, it could be intangible, or it could be both. So the opponents of traditional knowledge and traditional cultural expressions protection say, but you've always told us intellectual property is intangible. And now all of a sudden you are telling us traditional knowledge and traditional cultural expressions can be tangible, and they should still be protected by intellectual property rights. That is one negative characteristic that traditional knowledge and traditional cultural expressions have. The other negative characteristics may be that they don't jive with the concept of originality, or they don't jive with the concept of distinctiveness. Traditional knowledge, sometimes you are told this is handed down by word of mouth from one generation to the other, and you have no way of identifying who the authors of the traditional knowledge are. That, of course, goes against the grain of the intellectual property system, because IP says you need to know who the owner is, whether it's an individual or a company. And if we don't know the owner, then we will never know who the beneficiaries are, even if we wanted to protect the traditional knowledge and the traditional cultural expressions. So all these things come up, and sorry, this text is smaller than normal, and it's also lighter than normal. But today there's an increasing awareness of the risk of erosion of these traditional knowledge systems. There's an increasing awareness of the fact that they are capable of being exploited. There is an increasing awareness of their vulnerability and an increasing awareness of the value, the economic value they could come up with. So we have people who've been touting the need to protect intellectual property since 2001, when WIPO established its IGC, Intergovernmental Committee. Now this time it's the developing countries, because they have over 80% of the world's traditional knowledge, traditional cultural expressions, and genetic resources. It's the developing countries who are saying, let's bring TK, TCEs, and genetic resources into the intellectual property system, and let's protect it. And they don't even want to protect it at WIPO, where we don't have an enforcement mechanism. They want to go to WTO, knowing WTO has a dispute settlement system, and so there they will be able to protect traditional knowledge, traditional cultural expressions, and folklore. And that's why you can see we have forum shopping. Certain countries want the discussion to take place at WTO, but the developed countries, of course, are saying, even if we will have this discussion, of course it must continue at WIPO. So at WIPO, through what we call the Intergovernmental Committee, by the way, this is just an example of the Ghanaian government having protected traditional cultural expressions or copyright through copyright, until recently when the Kente Clause was no longer protected through copyright, but through geographical indications. So in WIPO, we have this normative development through the IGC, and the IGC has been trying to see how best to protect traditional knowledge and traditional cultural expressions. Now I'm just going to go to the new treaty, which I already talked about. Too many slides. GRATK. I mentioned the fact that it's not yet in force. We only have 3 actions in relation to this treaty. We need 15. I mentioned the fact that it's the first time indigenous peoples and local communities are mentioned in any WIPO treaty. And I mentioned that it establishes a disclosure of origin attribute. 24 signatories, I said, from Africa, and then Malawi and Uganda are the 2 that have actually ratified it. Albania has acceded to it, and we hope this treaty enters into force sooner than later. These are different aspects of enforcement, which is also on the list, but I thought I would incorporate them in a slide, and please feel free to use them as you deem appropriate. And on that note, I think I'm happy to take a break and take any comments or questions you may have. Thank you.
Some more flowers, please. Some more flowers. Thank you very much, Prof. Okay, as per our tradition, Q&A. The first 3 questions. Okay. Where are the hands? Okay.
Thank you so much, Doctor, for a wonderful presentation. I have, I think, 2 issues. I would like to seek your comment on that and your opinion on that. First, we are talking about the issue of dispute settlement. Although under WIPO, I have been attending various seminars under WIPO and RIPO. Now currently they encourage mastery on the ADR as the alternative dispute resolution to settle the intellectual property dispute. And I was consulting the AfCFTA protocol on the intellectual property rights. The same, it refers the dispute settlement mechanism to be followed under the AfCFTA protocol, the rules and procedure for dispute settlement. Although I was consulting the same to that rules, it considers some issues like good office, conciliation, consultation, which seems like mediation, which seems like the same as ADR, but it took too long. I would like you to seek your comment on how AfCFTA office for intellectual property that to be established line from ARIPO and WIPO. And the second issue, I was looking on the same Article 7 of TRIPO, which provide for promotion and technological innovation. Here, I would like to know how WIPO and specifically WIPO encourage young innovators, work hand in hand with young innovators with the various centers of innovation, and how it promote and how AfCFTA should learn from WIPO in promotion of young innovators who are under technology, who are under innovation centers as an incubator. Thank you.
Next question.
Hello. Thank you so much for that wonderful presentation. Mine relates to the TRIPS agreement, but I want to drift away from it and look at patentability. While there has been legal frameworks for patentability of different innovations, there seems to be an aspect with the upcoming innovations, especially the blockchains and digital currencies, digital technologies. Now, while there is a fair attempt to codify and bring space into which such innovations can be brought, there seems to be an issue with whether or not they fall under the industry applicable developments. But at the end of the day, we are finding them so much applicable to a large scale. I don't know whether the industry applicability aspect can be widened, but it seems that both at national level, regional and international, the frameworks do not accommodate such inventions, crypto, blockchain, as industry applicable. Please guide on that. Thank you.
Okay, the third question. Okay, Prof, we can proceed to answer as they are still digesting. The intellectual appetite is still awakening. Thank you.
Thank you very much. I guess this normally happens after lunch. You feel like your brains are getting frozen already, because I've just had two very difficult questions and I'm thinking how best to respond to them. The first one maybe is because I didn't quite get the question. You talked about the Arbitration and Mediation Center. You talked about the fact that the AfCFTA has mediation, has got good offices, etc. And you wanted to know if they can use innovation centers, especially in respect of the youth.
Okay, there are two issues. The first on dispute resolution, and the second one was on promotion of innovation. So the first on dispute resolution, I was trying to relate the current situation under WIPO, which promote mastery ADR as a mechanism to settle the IPR dispute, and what is provided under the AfCFTA protocols, specific to the intellectual property and the protocol to dispute resolution rules and procedure, which provide for those good office conciliation in which it seems like it sounds like ADR, but when you consider it takes too long and too long way to get to the dispute solved, as well as the one who are access to appear to that office are the state parties, which are different from WIPO, where you could, when a person has registered already, it's maybe patent under WIPO, he is able to seek ADR mechanism under WIPO. So I would like to know your comment on what AfCFTA should learn from WIPO specific to the issue of dispute settlement. And on the second issue, it was on the part of promotion of young innovators. As you said earlier, the WIPO office, almost its income, it depends from the registration that is done. So, and these young innovators, that are as the incubator and the innovation center are the potential customers of WIPO. And I would like to know the role of WIPO in encouraging those potential customers for them. That is all.
Yes, thank you very much. So you want to know if there's something AfCFTA can learn from WIPO. Let me be blunt and say I don't think so. I don't think so because, first of all, the WIPO Arbitration and Mediation Center only deals with disputes between private parties. And in fact, the reason it only deals with disputes between private parties, we had what we call a committee of experts, and in the 8-year period when WTO, GATT at the time members were negotiating the Uruguay round, WIPO too had a parallel session of its committee of experts on dispute settlement. And that committee of experts came up with a draft treaty, which was supposed to have gone to a diplomatic conference for adoption, so WIPO would be resolving disputes between states in intellectual property. But as soon as 1993 came, in April 1994, WTO signed the Marrakesh Agreement. 4 of our most powerful countries at the time, Australia, the United States, Japan, and Canada, said, WIPO, we no longer see the need for you to get into dispute settlement between states on intellectual property. So our legal counsel at the time, who subsequently became Director General, simply shifted the Arbitration and Mediation Center and made it expressly one that only resolves disputes between private parties. AfCFTA, there is no such restriction. So AfCFTA is going to be more like the WTO model where they have disputes between states. It won't be more like the WIPO model where it's disputes between private parties. So that's the one thing. On the second one, yes, promotion of young innovators. In fact, when our Director General did his medium-term strategic plan from 2020 to 2026, it's ending this year, he gave priority to 3 areas. One was small and medium-sized enterprises, one was women, and the third one was the youth. So we've actually just enacted what we call IPS. IPS stands for Youth Empowerment Strategy. And the whole idea is to make sure we encourage young people to be part of the intellectual property system, to promote young innovators, and using the IPS to encourage them to use their intellectual property assets. So yes, WIPO is paying particular attention to giving priority to the young people in all aspects of what we do, including through innovation centers, through small and medium-sized enterprises. But we are targeting the youth precisely because we take the position it's the youth who will become decision makers soon. And so we need to pay a lot more attention to them than we pay attention to older people like me. And that's one sense in which the youth are being encouraged, not just through the IP system, even institutionally. The World Bank and the IMF have always had what they call a young professionals program. Now WIPO has also started a youth empowerment program. We call it YEP, Young Enterprise Program, in which we bring youth to come and spend 2 years in the organization, and then they go back to their respective communities and go and disseminate whatever they learned while they were in WIPO. So we're targeting the youth in all aspects of what we do, including in respect of innovation centers. Thank you. The other question was on patentability. And you talked about the fact that we have blockchain, we have digital technologies. You mentioned different search engines, and you are wondering whether these don't all satisfy the patentability requirement of a new and inventive step. Industrial applicability, which is what you get to after you've gone over the new and inventive step. As you know, you need the novelty, you need the new and inventive step, and then you need the industrial applicability. But when it comes to the industrial applicability, in my mind, I think the areas you mentioned are closer to copyright than to patents. So, for example, we are talking whether it's blockchain or the metaverse or non-fungible tokens, these are all more closely related to the copyright area than to the patent area, which is why I don't think they are as applicable as industrial applicability. And incidentally, you will recall it's also TRIPS that has now made computer programs, both source and object code, copyrightable. So I think most people would place these areas you've mentioned more under the copyright system than under the industrial property system. Yeah.
Otherwise, if you don't have questions, Professor is going to ask you. Yeah. So to avoid questions from this side, we better ask questions.
Thank you.
My questions would actually have been nice. They wouldn't have been that bad.
Just picking up on your last response, Dr. KWAKWA, on the issue of machine learning and all these developments and how much they need access to data and even copyrighted works, how adaptable is the current architecture of IPRs able to ensure that there is meaningful protection of those works when these new technologies are actually requiring access to the same materials, but more or less without due regard to the pre-existing IPR rights of the authors and so on? Is there, even when you talk about the traditional knowledge and all those other forms of rights that are emerging, how secure can those rights be in the light of this very invasive technology that is more or less reconfiguring how life and business is conducted, as it were, because of its very invasive nature and how easily it can reproduce other people's works, and how even we've heard of developments even in Hollywood where certain jobs that were done by people now can easily be done by machines or technology. How much is the current system adapting and responding to these very disruptive technologies?
Thank you. Okay, another question there. You. Wait until we get the other question, Prof. Thank you. Mic testing, 1, testing 2.
Oh yeah, thank you very much for that presentation, Prof. I only wanted to, because I'm not too familiar with IP regime, but I was just wondering to what extent the reform on the TRIPS goes against the parallel import. Because we said that if a country is unable to produce generics, that they can rely on another country for that, and that the medicine or the provision that made room to prevent that from happening has been removed. So I was just wondering to what extent the current regime guarantee that it doesn't happen.
Okay, there is a third question here.
Thank you very much. Thank you, Prof. It's a bit maybe off the mark, but I just want to solicit your views on the Makate-Vodacom matter. If you followed it in South Africa, the Please Call Me matter. It would be interesting for me just to hear your opinion on that one. Thank you.
Prof, proceed.
Thank you very much. Let me start with, you said McCarthy Vodacom. Unfortunately, I don't have any clue what that case is about, but I'm happy to engage with you bilaterally, and if you tell me about it, I'm happy to tell you what I think about it. But you can be sure I don't know anything about it, so sorry for that. On TRIPS, and you were wondering how the amendment to TRIPS affects parallel imports. So I don't think they are necessarily seen as the same regime. When it comes to parallel imports, as you know, what that entails is if you put goods in another market, the minute they go into the other market, the idea is that you've lost your right of control in the original market in which you had it. When it comes to the amendment to TRIPS, what it is saying is that you undertake the compulsory licensing in your own jurisdiction, but you undertake it under specified conditions, including with compensation to the patent owner. So it's two completely different regimes, and the parallel importing is part of TRIPS, just like compulsory licensing is part of TRIPS, except compulsory licensing is a subsequent amendment specifically to take care of the fact that a lot of countries were not benefiting from the compulsory licensing because there was that language about keeping it only in your domestic market, something that doesn't apply to parallel importing the minute you import it to another country. Sorry. New rights, how secure they can be. Yes, yes, that was here. So I agree with you. Well, first of all, I think we are all operating on huge assumptions. In WIPO, what we go out of our way to say is that the international community is not ready for any type of legislation when it comes to frontier technologies, in particular artificial intelligence. And the reason we say that is because we think artificial intelligence is changing by the day. And this is probably one of those areas where people say the law comes only after the technology. So let's wait for the technology to settle and then we'll come up with legislation. The problem is the technology is changing faster than anyone can do anything about it. So you have, for example, the Dabus case, where South Africa ended up being the only country that says artificial intelligence can own intellectual property. But then a lot of people said, let's interpret the South African case in the context of the fact that they don't do substantive patent law examination. The point I'm making is, in WIPO, we say to our member states, you guys are not ready to legislate because you don't know what frontier technologies are. The government of South Africa will define artificial intelligence differently than the government of Tanzania will, and different countries have different definitions. So we are at the stage where we keep saying all we are doing is we are having conversations on IP and frontier technologies. Incidentally, even the frontier technologies, we are now limiting to just artificial intelligence. So we'll stop talking about blockchain, Internet of Things, any other type of frontier technologies. And we take the position, let's just exchange views. We are not going towards legislation. And so any new rights that come up will have to be in the context of domestic legislation. Having said that, we realize the European Union has actually come out with what they call regulations for AI. And we think it's just the beginning of what other countries are going to do. But we don't think our 194 member states should be heading in that area. But we are not their boss, so we don't tell them what to do. So my short answer to your question is, I don't think traditional rights are that secure, or maybe I should say, it's hard to tell how secure traditional rights are when we don't know what new technologies are coming up and the extent to which those new technologies will affect traditional rights. Yeah.
Okay, the next, probably last 3 questions. Okay, the last 3 questions. Okay, so we are going to ask you, since you don't want to ask. All right, Prof, I have a question also, and then I'm sure 2 people are going to ask. So my concern, it could be from the veil of ignorance, because I think things have evolved since I was involved in intellectual property rights legal battle. My experience was where you have these like computers. If you have individual computers, I think they used to allow a threshold of not necessarily piracy, where you can download things without paying for it because you're using it as an individual. Now, my question still remains, is on the threshold, because what happened in that case was that at a law firm where I was working, apparently we were more than 15 people who had downloaded, but in our individual capacity, but then working for the firm. So then we were served with Anton Pillar's order and so forth, saying that we had breached the intellectual property rights. But then we were individuals. So I want you to help us navigate when individuals meet. What is the threshold of saying this is where an individual can go in enjoying intellectual property rights without paying for them? And then I'm waiting for the other 2 are going to ask so that we make it a nice meal. If the other 2 are not going to ask, we are going to ask them, don't worry. Oh, I see my brother from Zimbabwe is trying to... Are you trying to raise your hand? You are stretching? Okay, the other 2 questions? Okay, proceed.
Yes, so Elvis, I hope I understood your question, but clearly if you are talking about individual violations as opposed to collective violations, you said at one point there were 14 of you in the law firm, all violating the same thing. So that's 14 different violations on 14 different people. No one is going to count that as one violation by 14 people. In other words, copyright law stands such that it's going to target individuals who violated one at a time, not collectively.
Understanding also, but in this case, actually, they managed to get the order in the sense that they thought that we are trying to do sharp practice. There's what you call sharp practice in Zambia, where you know that if we go as a law firm to buy computers and we download them for free, it will be collective. But then for them, they thought we were given money by the law firm to buy individual computers and download as individuals. But actually, we were just individuals. But still, this case went on, and eventually, we had to settle out of court.
Exactly. I was going to say you either lost it or you had to settle. But we all don't know what the future of copyright has for us. So you've just asked this question. I have 3 sons. One of them, and this is the last of the 3, he's 22 years old now. He's made it his specialty to know when he can violate IP rules. Or I say violate in the sense that when he goes to the US, he knows he can't download something on Netflix. When he comes home to Switzerland, he immediately sits in front of the TV and he does it. And he says it's allowed in Switzerland. It's not allowed in the US. So we are at the stage where even teenagers are studying what jurisdictions allow them to do things that would be violations in other jurisdictions.
Yeah, I think that's one of the things I think where we're going to go, because it's like there are these electronic books that you can download for free in Africa or rather in Global South, but you cannot do in Global North using this Libre Genes. Yeah, you can download for free. And then on the other hand, there are certain books that you can download on the libraries in the they call it EduROM, where you can connect if you're a university student in Europe. You can read them there, but then on the same book, if you are outside the EU zone, you don't have access. It shows you blank pages. You know, these technologies are now destroying the world.
I would say rather than destroying, they are revolutionizing the world.
Very much, Prof. Please, flowers for Prof.